Is Social Security disability testimony via telephone legal? Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the Disability Help Book, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. As a Social Security disability attorney, I hear all kinds of questions and concerns from clients and potential clients about the claims and the hearings process. Part of the reason for this is that the SSA doesn't go out of its way to ensure people have access to the necessary rules and procedures in order to make their claim and to fight for their rights. But there's another reason too. On some things, the SSA is just plain vague. For years, the question of the legality of telephone testimony from medical experts, vocational experts, and others that fell into this category were unclear. Because SSA rules didn't specifically address it in one way or another, it was left up to the judges presiding over the case to make the call. Well, no longer. This past June, the Social Security Administration finally created a rule to address the issue. The verdict? Telephone testimony is allowed in Social Security disability hearings as long as the side asking to use it gives advance notice to the opposition. This is an unfortunate turn of events for anyone appealing a decision by the Social Security Administration, because a lot can be lost in translation when somebody gives telephone testimony. That's a big deal when you consider that the judge tends to base a significant percentage of the rulings on the credibility of these expert witnesses. How can they possibly tell if someone knows what they're talking about or seems trustworthy when they can't look at them in the eye? This may seem like a minor thing to complain about, but consider how much of your communication is visual. Often there's more to learn from somebody's body language than there is by simply listening to them speak. Not only does the opposing side need to be notified in advance if telephone testimony is going to be used, they have the option to object to it being used in the hearing. Now, this objection doesn't mean that it won't be used at all, but it does mean that the judge has to look at the circumstances surrounding the case and make a specific ruling about the type of testimony that will be allowed. You won't even get that consideration, though, unless your lawyer makes the objection. If you have more Social Security questions, check out my free ebook, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.